abrogation in accordance with due process of the law. Number 2, jurisdictional and procedural objections on constitutional immunity of His Excellency Dr. Riek Machar, our first Vice President of the Republic of South Sudan. First and foremost, we want to bring to the attention of this Honorable Special Court that the instance of preliminary legal objections pertaining one of jurisdiction of this Honorable Special Court is that the legal objection meant to terminate an infancy or as well to nip it in the bud without wasting the time, dispersing unnecessary energies in considering unworthy or fruitless matter in the court proceeding. It, in other words, forecloses hearing of the matter in order to save time. Your Lordship, Article 103 and Article 104, Clause 2 of the Transitional Constitution of the Republic of South Sudan as amended, read together with the provision of Regulation 62 and 63 of the Transitional National Legislature, which is here. This is our Constitution, and this is here. This one. Read together with the provision of Regulation 62 and 63 of the Transitional National Legislature, Conduct of Business Regulation 2013, amended 2021, provided that the first Vice President shall not be subjected to criminal proceeding while in office. Except upon proper removal of immunity upon a resolution passed by a 2/3 majority of all members of the National Legislature. Article 104, Clause 2 of our Constitution read as follows. The Vice President may be removed by the President or by 2/3 majority of all members of National Legislature. The provision of Regulations 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021, entitled Immunity and Impeachment of the President, the First Vice President, and the Vice President. Regulation 62 read as follows. Impeachment of the President. The President shall be immune from any legal proceeding and shall not be charged or sue in any court of law during his or her tenure of office. 2. Notwithstanding sub-article 1 above, in case of high treason, gross violation of this Constitution, or gross misconduct in relation to national affairs, the President may be charged before the Constitutional Panel of the Supreme Court in the Republic of South Sudan, and upon a resolution passed by a 2/3 majority of all the members of the Assembly. Clause 3. The President of the Supreme Court shall within 7 days after receipt of the impeachment notice referred to under sub-article 2 above, constitute a tribunal comprising 3 justices of the Supreme Court to evaluate the allegations in the notice and to report to its findings to Constitutional Panel of the Supreme Court. Number 4, Clause 4. The President shall be entitled to appear at the proceeding of the tribunal and to be represented by a lawyer or other expert or any other person of his or her choice. Number 5. If the Constitutional Panel convicts the President, it shall communicate its final verdict to the Assembly, and he or she shall be deemed to have fulfilled the office. Your Lordship, this provision is applicable to His Excellency, the First Vice President, according to provision of Regulation number 62, 63 of the Transitional National Legislature Conduct of Business Regulations 2013 as amended 2021, which read as follows. Regulation 33, removal of the first vice president and the vice presidents. The provision of Regulation 62 shall, with necessary modification, apply to in respect of the first vice president and the vice president. The question arises here is, when does a court become competent? A court becomes competent when it is properly constituted as regards members and qualifications of the members of the bench, and no member is disqualified for one reason or the other. Number two, the subject matter of the case is within its jurisdiction and there is no forfeiture in the case which prevents the court from exercising its jurisdiction. And three, the case comes before the court initiated by due process and upon fulfillment of any condition precedent to exercise of the jurisdiction. My Lord, Your Lordship, any defect to these 3 points on competence of the court is fatal. For the proceeding are nullity, however well conducted and decided. The defect is extraneous to the adjudications. For the above legal points 1, 2, and 3 go together in the circumstances of the instant case, the 3 points were not fulfilled for the following ground. 1. The Honorable President of the Supreme Court of South Sudan has no jurisdiction to constitute a special court in case of the first Vice President, His Excellency Dr. Riek Machar Teny, our first Vice President of the Republic of South Sudan, which is subject to impeachment upon resolution passed by a 2/3 majority of all members of National Legislative Assembly, provided in the provision of Article 104, Clause 2 of the Constitution of South Sudan, read together with the provision of Regulation 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021. Therefore, the order of establishment of this Honorable Special Court by Honorable the President of the Supreme Court of South Sudan is ultra vires, beyond its mandate. It is unconstitutional, it is illegal, it is unlawful. Therefore, the sitting here is wasting of resources and time. That beyond his jurisdiction for him in the provision of Section 16(4) of the conduct of our Criminal Code of Procedure. The only power of our President of the Supreme Court is only to constitute or to establish a special court for trial of juvenile offenders. These are not juvenile. To form High Court to preside, convince of preside, a special court to be presided over by the High Court or any senior justice, which is not the case here in the case of the first Vice President. And number 3, a High Court judge may convince a special court. This is not irrelevant, it is irrelevant. So, which is stipulated that the President of the Supreme Court may, by order, constitute a special court for the trial of any accused under chapters 4, chapter 5 and 7 inclusive of the Penal Code. Number 2, lack of a resolution passed by 2/3 majority members of all members of the Transitional National Legislature Assembly as provided in Article 104, Clause 2 of the Transitional Constitution, read together with the provision of Regulations 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021. Therefore, the arrests and detentions of the first accused, His Excellency Dr. Riek Teny and his brothers, were carried out without lifting the immunity, rendering this proceeding unconstitutional, unlawful, illegal, and void ab initio. The right to be tried before a competent court, independent and impartial tribunal is guaranteed under both international treaties ratified by the Republic of South Sudan and the Bill of Rights in Part 2. Bill of Rights is here in Part 2 of our beautiful Constitution, from Article 9 through Article 34 of our Constitution. It is about the Bill of Rights, it is about human rights, it is about the due process of the law, it is about the crack of the whip. Number 3, relief sought. Wherefore, His Excellency Dr. Riek Machar and the 7 accused persons respectively pray this Honorable Special Court to order in their favor as follows. Number 1, order this Special Court lacks of jurisdiction and competence to try this matter, and therefore null and void ab initio, pursuant to the absence of fulfillment of the requirements stipulated in the provision of Article 104, Clause 2 of the Transitional Constitution, read together with the provision of Regulation 62 and 63 of the Transitional National Legislature Assembly Conduct of Business 2013 as amended 2021. Number 2, order the immediate discharge, release, and go home of His Excellency Dr. Riek Teny and his brothers from this court, and let them go home from today. Let them go home and have the business to do their job. Order the immediate discharge of His Excellency Dr. Riek Teny, the first Vice President of the Republic of South Sudan, and the 7 accused persons for being arrested and detained unconstitutionally. Number 3, Your Lordship, any other relief this Honorable Special Court deemed fit, respectively submitted, date today, 22nd day of September 2025, Defense Advocate Dr. GERI RAIMONDU LEGE Lobate, the lead advocate. Number 2, Advocate Kurlu Alkur, member. Number 3, Advocate Deng John Deng, member. Number 4, Warnyang Kir Warnyang, member. And finally, Advocate Anis Tombe Agustino, member. All, thank you so much. Thank you, my Lordship.
After hearing the application of the defense, now we would like to give chance to the prosecution to reply.
My Lord, allow us to reply to our colleague, Dr. GERI, for what he has raised of his objections. This will be represented by one of the panel, Advocate Newell.
Your reply will be in